Hi, it's John Cohen at Nextlaw. This video is part 2 of my new stunt driving laws in Ontario videos, the MUMS Act, Moving Ontarians More Safely Act, and is focusing more on what not to do in court rather than the court process itself. And as I said before, our law firm defends, over 500 clients each year with stunt driving charges in Ontario, which means that we do more than double or triple that in phone calls. So this video is about listing different series of reasons that people give for their stunt driving charges in hopes of mounting some sort of defense. So first, how does the law see your stunt driving charge? Well, most of you may not like the next statement, which I've said before. It is not coming from me. Rather, it's coming from the way in which the province of Ontario, the prosecutor, the actual law, views your stunt driving charge. In simple terms, the province only needs to prove that you are above the speed limit of 40 kilometers per hour on a road less than 80 kilometers per hour limit, or a speed limit of 50 kilometers per hour on a road of 80 kilometers per hour or more posted speed limit. And that's it. It's that simple. So one of the common reasons for stunt was it was an emergency, etc., etc. And often clients will tell me on the phone that they are law-abiding drivers. They were having some sort of an emergency regarding either themselves or someone close to them, and that is when the radar caught them and they were charged by the police for stunt driving in Ontario. Now, while this may sound logical when debating your charge, the bottom line is that the law does not generally care about any of the reasons or circumstances as to why you were stunt driving. If the radar caught you at a speed classified as stunt driving in Ontario, then that is enough to convict you in most circumstances in court. So in order for this to be a reason, you would have to have some sort of evidence, whether a doctor's letter or a letter from the police or the hospital, that shows that at the time of the stunt charge, you were following a professional's instructions, which led to the reason for the high speed. And even then, it may not be enough to convince a prosecutor or a justice of peace. So what are some of the emergencies that we have heard from different clients? Now, don't get me wrong, we're not dismissing any of these reasons below. They are very serious to the driver and or to the client. However, we're just trying to demonstrate how the prosecutor regards these reasons. So reason 1, I had to use the washroom. It was an emergency. Reason 2, I had to get to the hospital. I wasn't feeling well. Reason 3, I had to get to the hospital because someone I care about was not well. Now, keep in mind that everything in court is evidence-based. So I think the easiest way to think about how a prosecutor will regard your emergency is what evidence can you present to back up your story. Simply telling the prosecutor that you had an emergency is rarely a reason to have the charge dismissed. All the prosecutor, as I've said before, needs to prove is that you were stunt driving. So your explanation would need to be backed up by solid evidence. Otherwise, it's generally not a strong enough argument to counter the fact that a calibrated speed radar has you going over the posted speed limit into stunt driving territory. So, is there nothing I can do? I'm going to lose my license for 1 to 3 years. Well, just because you've been charged with stunt driving, it does not mean that you will be convicted of stunt driving. There's a big difference between those two terms. The charge is just the beginning of the legal process. And yes, it is a devastating start because now you have this horrible 14-day car impound and a 7-day, soon to be a 30-day license suspension at the roadside before you even get to your court date. So now it's time to get some legal advice and proceed very carefully. While stunt driving may seem like a general traffic charge that many people may not take seriously, it's better to look at this charge and think about it more as how you would function if your license was suspended and you could not drive for a minimum of 1 year. Because with that in mind, you run the real risk of losing your job and not being able to get to job interviews for a new job, or not being able to take care of your family, not being able to use a car for emergencies, and 1,000 other valid reasons. So that's how serious this charge can be if not dealt with properly. And again, I keep saying this is not a video to get your business. We're not there yet. Rather, it is a video to get you to reach out and get some free legal advice, because if you can get that from a proper law firm that specializes in stunt driving, that may have a strategy for you. We may have a legal course of action that could prevent this license suspension. And best of all, the call should always be free. So you can scroll down below or check below in the description and book a free meeting with Dan Joffe or myself, John Cohen. There's no obligation, but the call could change everything.